AT1 bonds and legal options. What investors should consider. Now the write-down of the Credit Suisse AT1 bonds marked one of the most controversial moments in recent Swiss financial history. Billions were wiped out. Investors were left with significant losses. The legal and political debate has not stopped since. Recent court decisions have added new dynamics to the situation. In particular, developments before the Swiss Federal Administrative Court, the Swiss Federal Supreme Court, and US courts have reopened questions about the legal basis of the write-down. The core issue is whether the FINMA emergency order that triggered the complete write-down was legally sound. Parts of that framework have now been critically reviewed by the courts. For investors, this is not an academic debate. It has practical consequences. Several legal avenues may be relevant. One is state liability. If unlawful state action can be established, compensation claims against the Confederation may be possible. These proceedings are complex and subject to strict procedural rules. In international constellations, arbitration proceedings may also be an option. Jurisdiction, governing law, and limitation periods differ from case to case. Timing is critical. Certain claims are subject to statutory deadlines. Missing these deadlines can permanently bar recovery. At the same time, not every investor situation is identical. The exact bond documentation, acquisition date, place of purchase, and investor classification all matter. The path to compensation is therefore legally demanding and strategically sensitive. However, the path to compensation remains complex and deadline-driven. Lindemann Law is your partner in such matters. Our litigation practice knows the subject matter, the jurisdictions, and the tactics from state liability to civil action to arbitration, and will enforce your claims in a targeted manner. Contact us. We will advise and represent you competently and effectively in this area of law.